Well, welcome to our International Nuptial webinar. My name is Kim Beatson, and I'm a family lawyer, a mediator and a collaborative lawyer practicing in London, England. And I'm joined by Katja Ziehe, a family lawyer from Switzerland, Francesca King, a family lawyer from Italy, Suzan Aiken, a family lawyer from California, and Cath Karlin, a family lawyer from Edinburgh, Scotland. And the purpose of our webinar is to share our experience of how nuptial agreements work in our respective countries. In England, nuptial agreements are not binding on our family courts, but they are of compelling importance, particularly when both parties have had legal advice, where they've made full financial disclosure to one another, and the outcome on separation or divorce meets the needs of both parties and particularly of their children. It probably goes without saying that there must not be duress, and the agreement must not be made in fear of the other party. But there's no need to choose a nuptial agreement on marriage, and there's no default position in terms of excluded property or future assets, and there are no formalities in terms of registration. So I imagine it's going to be quite different to the position in the countries that we're going to be talking about today. And I have several questions to ask my international colleagues, all of which will demonstrate the importance of taking cross-border legal advice from specialist lawyers if your clients are likely to reside in other jurisdictions or have assets abroad. And I'm going to start with you, Katja. And the first question is, do clients have to comply with any formalities if they enter into a nuptial agreement in Switzerland?
Oh, yes, they have to have a written agreement and it has to be notarized. And, compared to England, there are only a few topics that you can put in a nuptial agreement. So it's only about the assets. You can only have agreements on the assets. You may not do, agree on anything regarding maintenance. It's just not accepted by Swiss courts.
Thank you. And Cath Karlin?
Yes, again, we need a formal written anti-nuptial agreement. It must be signed and dated by witnesses, not notarized, but definitely signed and dated. You can add pretty much anything you want to the agreement, but what you cannot do is exclude provision for maintenance, either spousal maintenance or child support. So whilst you can actually add in provision for maintenance or child support, you can't exclude either of them.
Thank you. I think the next person I was going to ask was Suzan, California.
Yeah. So in addition to the agreement being entered into voluntarily, free from fraud, undue influence, coercion, or duress of any kind, enforceable premarital agreements in California must comply with the requirements of the Uniform Premarital Act. And that act requires that the agreement be in writing and signed by both prospective spouses, that the individual against whom enforcement is sought be represented by independent counsel when the agreement is signed, or after being advised to seek independent counsel, the individual expressly waives representation in a separate writing. The advisement to seek independent counsel must be given at least 7 calendar days before the final agreement is signed. What's also super important is that the disclosure of property and financial information must be fair, reasonable, and full. There must be at least 7 calendar days between the time a final agreement is first presented to the prospective spouse and the time it is signed, regardless of whether the prospective spouse has represented by legal counsel. A self-represented prospective spouse must be fully informed of a premarital agreement's terms and basic effect, as well as the rights and obligations a self-represented prospective spouse is relinquishing by signing the agreement, with such advice memorialized in writing. So that's when you have one spouse is represented by counsel and the other spouse isn't. I personally don't think that's a good idea, because it is always subject to some kind of attack when it doesn't give the prospective spouse who is unrepresented an entirely full description of those things that I just mentioned. And the agreement cannot be promotive of divorce, and the agreement cannot be unconscionable when executed.
Thank you, Susan. And the position in Italy, Francesca?
Well, the position in Italy is quite similar to the position in Switzerland, as Katja was describing it. So the only nuptial agreement that is recognized by the law is the agreement regarding assets and what happens with assets that are acquired during marriage. It has to be a written agreement and a notarized agreement. The only exception is if the choice of how assets during the marriage are going to be dealt with is made at the moment of the marriage and registered in the Marriage Act. There is a default system, which is the community of assets that are owned during and after the marriage. If you don't make that a different choice at the moment of the marriage, this is what your assets will look like, and the property regime will be that. There are not much alternatives that you can choose. There is a separation of assets, and that is something that you can decide at the moment of the marriage or afterwards if you change your mind.
Thank you. Now, I know all of you through the International Academy of Collaborative Practitioners, and I think it's fair to say that you're all prominent collaborative lawyers. But what sort of process do you prefer when you're negotiating a nuptial agreement? Katja?
Which would I prefer? I would prefer to have actually two collaborative lawyers advising each party. But in reality, mostly the people come to me, just by themselves. They don't take lawyers. They just take me as a mediator to mediate the nuptial agreement, and that's reality. But I would rather prefer to have each spouse, properly advised. So that would be a very good opportunity to use the collaborative lawyer on this other side without having the actual process, but having two lawyers who are focused on finding a solution for the people, for the couple, and not trying to trick or trying to get advantage out of this.
So if you're mediating a nuptial settlement, can you draft it?
Yes, when the couple gives me, asks me to do it. Okay, so I do the mediation and I draft it on the flip chart. Okay, what they agreed on, and then they give me another assignment to draw up the agreement, and then I do that.
And do they then have separate lawyers?
No, not necessarily, but I always, when I do mediate, I ask the clients to go to see, to seek advice, legal advice before signing. On the other hand, it's not very complicated, regarding the assets. The nuptial agreements are not very complicated, so it's not really necessary. And sometimes even a notary, when they get notarized, the authorities, they give in their own peace of mind to the nuptial agreement, so they will give some advice too when they sign it at the notary.
Okay. And Kath, what process options do you use?
Well, obviously I would like to use collaborative a lot, and I have done in the past, but that I have to say, unfortunately, is very rare. again, what tends to happen is that either one person comes to me, or alternatively, a couple are referred by the respective lawyers, and I end up mediating. With mediation here in Scotland, I couldn't draft the agreement. I would be forbidden from doing that, and anything, in fact, that the couple agree at mediation is non-binding on them. I mean, I guess that's why dealing with it collaboratively here is better, in the sense that they've got the respective collaborative lawyers working with them throughout the process. But as I say, generally, it would be simply negotiating back and forward. I could potentially just act for one party and send an agreement to the other, but I would have to tell them to take their own separate legal advice, and inform them that the contents of this agreement were, legally binding and could have severe implications on them if they chose to sign it without taking advice. But technically, I could do that. I would be very reluctant to do that, but technically I could do that. And it would basically be up to, I guess, the court at the end to work out whether or not that party had had sufficient advice and sufficient time to reflect. But, as I say, it's definitely possible. And there are agents out there who do that.
And Suzan, you do not litigate.
I do not.
So I'm interested in your preferred process options.
Yeah, so sometimes I will mediate a prenuptial or postnuptial agreement, and then there would need to be the attorneys involved from my perspective. So then you have three professionals. So the process that I prefer is either a collaborative or cooperative law process. And the way that that would work is after meeting with my client and becoming familiar with what's important to them, we would meet with their partner and his or her attorney to start to clarify the couple's values, goals, and interests, so we can find out what's important to both of them, and which will be reflected in the final agreement. I mean, the idea here is that people are about to get married, and so what we really want to do is not create a situation where in doing this, we're really kind of like dealing with them in a way that's not healthy for their relationship. So we really want to work with them in a way that will help them preserve their relationship and also feel free to disagree. I've worked with, in a collaborative process, I've worked with mental health professionals when things are really challenging, because sometimes people will talk about what they want and they're about to get married, or they're going to be married, within several months or something like that. And we don't want to have a situation where, all of a sudden someone feels like, oh my gosh, I trusted you, and it can be very challenging and hard for people when they have different perspectives on that. So rather than having a situation where one attorney goes and they prepare the agreement and they hand it to us and we're, whoa, oh gosh, we build it up together. So what I really like about this way of doing it this way is that we build it together, and then one attorney will prepare the agreement, and that will reflect what the couple has said. This is what we wanted to say. And my counterpart, the other attorney, will review it, and we will prepare that agreement. And once we believe that agreement reflects what the couple wants, we will give it to them and they will review it. And then we'll go back and forth in that way. And so what I really like about this is that as an attorney, and I love drafting agreements, is that we can prepare an agreement that really is an excellent job about, here's what you wanted to say, and here's what it says.
It's a sort of premarital therapy, examining how people feel about money and how people feel about illness or unemployment. I think it can be very valuable. It's an ideal way of working. Is that how you do it too, Francesca?
Well, really, in Italy, since there isn't in our system a tradition of having nuptial agreements that are not more than a simple choice of what you want to do, with no really ability to craft what's in that choice. There isn't a tradition of negotiating agreements, prenuptial agreements or nuptial agreements. As I was saying, traditionally, the only choice you can make is what is going to happen to your assets that are acquired after marriage. And the only real alternative is, are they going to be common assets, or is each going to keep the assets that he or she buys? So this is something quite new that's entering in the law practice, because especially with cross-border marriages, prenuptial agreement have become more and more a topic of interest. Also, our legislator is now interested in it, and there is a project of law that's waiting in Parliament to be discussed. We have no idea what's going to really happen. And there have been some, there is some case law that actually deals with some aspects, some agreements that have been met. So I can't really talk of my experience in this, but I can surely imagine that having the possibility of sharing a process where lawyers are there to help parties reach an agreement, where parties will be able to share their interests and values, and then build their agreement. I think that's an incredible opportunity. So I would surely say my preferred way to do this, if I could, would be collaboratively, yes, or cooperatively at least.
Yeah. Now, we've heard that in Italy and in Switzerland, nuptial agreements deal with assets. They do not deal with maintenance for a spouse or for children. In England and in Scotland, nuptial agreements often deal with maintenance. Is that the case for you as well, Suzan?
Yes, it is. So prenuptial agreements, they can include provisions for, we call it spousal support, as long as the individual against whom enforcement is sought was represented by independent legal counsel at the time the agreement was signed. So this is a situation where there has to be lawyers involved, or it's not going to be enforceable. However, when the agreement is at the time that someone says, you know, hey, I'm going to challenge this agreement, if the spousal support provision in that prenuptial agreement would be unconscionable at the time that it's being addressed, then it can be thrown out. So for example, if there is something in there that says there's not going to be any spousal support, so agreements that I would work on would say it's going to be limited in such way, there isn't going to be any spousal support, all those kind of things. If at the time that enforcement is sought, that it would be unconscionable, like someone would be not able to support themselves, or perhaps the couple agreed that they would stay home to take care of their children and they have no skills at that time, then that prenuptial agreement, that provision for support, that would be in trouble. The law is unsettled as to whether a postnuptial agreement, an agreement of this type within a marriage, if a spousal support provision in that type of agreement would be enforceable. And child support provisions, like most things having to do with kids in these kinds of pre and postnuptial agreements, are absolutely not enforceable.
And I think you know that in England and in Scotland, there's no need to choose a nuptial agreement, and there's no default position. In Francesca's country, in Italy, there is a default position, and you must choose a nuptial agreement. How does that work for you in Switzerland, Katja?
Well, you don't have to choose, because we have a statutory marital property regime. So if you don't choose anything, then the participation in acquired property, that's the rule, okay? So anything that you have before marriage will remain yours, and anything that you acquire during marriage is subject to a split if the marriage ends either by divorce or by death, right? So in the nuptial agreement, you can choose either the separation of property, or you can customize the participation in acquired property a little bit to your needs. And there's a third option. You can choose the community of property, which is very rare, that everything that you own is, it's both, it's the property of both. So that's very unusual. It used to be more, I think, in earlier times. And if you have like a farm or farmland, so this might make sense. But in today's times, it doesn't make any sense to declare everything both as, everything's it's both to both of you, of us. So the default position is actually something that's considered fair by the law. Okay, so everything that you acquire during marriage, you should share, but you don't have to. You can even make an agreement later on when you get divorced and not split it. But that's a decision that you can make later on.
So the default position is covered by statute, effectively.
Yes.
And sorry, Francesca, were you?
Sorry, just to make sure. Also, this is the same in Italy. You don't have to choose. There is a default system that would operate in any case if the couple doesn't make a choice, which is, as in Switzerland, the regime by which whatever is acquired after marriage is to be shared. You maintain ownership of what you had before or what you receive by donation or by inheritance. Otherwise, it is shared. I think it's very similar. And the only choice you can make, you cannot customize, as Katja was saying, but you can choose the separation of assets. And that is a choice that you can make at the moment of the marriage, or you could make during marriage, and that would change what happens before. And that has to be a notarized agreement.
In England, we have a totally discretionary system. So assets that you had before, assets that were inherited, they could all become part of a marital disagreement. And that's different to Scotland, isn't it, Cath?
Yes, absolutely. We have our default positions contained in the Family Law Act 1985. And basically what that does is it says that all assets which have been acquired by the efforts of one or both of the parties during the course of the marriage are matrimonial, with the exception of gifts from third parties and also inheritances, which means that we've got very, very finite cut-off points. So date of marriage, date of separation, all assets are valued at date of separation as well. So that you separate in 2015, you don't deal with a separation agreement or a divorce until 2021. The cut-off date for all valuations is 2015, apart from the matrimonial home, which is valid as at the date of divorce. So we are, our system is actually pretty rigid anyway, so that oftentimes people don't really bother with prenups because they know that assets they have pre-marriage, any inherited wealth, and also any gifts they get from parents, for example, will not be part of the pot. Where it becomes a bit problematic is basically life tends to get in the way. And what people always do is they say, right, okay, I'm not just keeping this inherited £100,000 to one side. What I'm going to do is we're going to buy a new family home. We're going to make it bigger and better. And I'm going to apply the money to renovations. And of course, once you do that and you change the nature of the inherited wealth, it becomes matrimonial. So really for us, what we try to do, I think, with prenup agreements is we try to avoid that situation. So any transmutation of non-matrimonial property into matrimonial, that's really what our prenups are designed to protect. So any increase in value, say for example, in a house over the course of the marriage, we would say that was kept out. So what you tend to find with lots of our prenups is that there's a big schedule at the back, which details all the assets that were there before marriage, all the assets that might be inherited, and we list that all of those assets are exempt, and also that the free proceeds of those assets and any assets that those assets then purchase are also out of the pot.
We do that too sometimes, yeah.
Yeah.
And Susan, how does it work in California?
In California, the default is California law, which is similar to what Cath was just speaking of. We are a community property state. So what I find is that particularly with younger people that are coming to me now, the idea of community property where, you know, everything that's a product of your efforts during your marriage, whether that's your paycheck, a contribution to your retirement account, you know, creating a work of art, any of those things that you create from your date of marriage to your date of separation, that is community property. And for the trend that I see is that younger couples, that doesn't make sense to them. And so often what I will do in an agreement is that the couple will want everything that's a product of their efforts during their marriage to remain their separate property. And then they will have a joint account that they put their money into. That joint account, it's separate property. When it goes into that joint account is designated as community property. So everything that comes out of it that they buy is community property. So they use that account very often for paying their expenses that they agree upon. And some people are very particular about what joint expenses are, and some people are not. But whatever they put into that account, if they, for example, wanted to buy something, a vehicle or whatever it is that they wanted to purchase, and they wanted it to be community property, they would buy that out of that account. So the money that goes in is separate, it comes out, it's community. And that's something that people often do. Also, a premarital agreement in California, if you have something before marriage, it's your separate property. It remains your separate property. If you have income that flows from that property, even during your marriage, it remains separate property. If you take your separate property and you buy something new during marriage with that money, as long as everything is kept separate, it remains separate property. But sometimes what happens, for example, is let's say someone comes into the marriage and they have a home and it is their separate property. If they start paying down the mortgage and paying the principal down on the mortgage, or if they make improvements to the property with their earnings, now what you have is a situation in which community property has been contributed to this separate property, and now you have a mixed asset, and this is where things become more confusing. The situation with, when are things valued is very similar to what Cath described, and that is, a home, if you have something and it also holds true for if there's a debt, if they have a credit card, for example, we would look at their credit card statement and say, okay, here's the date of separation. Anything that is before, if it's a living expense, it would be a community expense, and after would be a separate expense. All of that becomes mixed up with, duties of support and all that stuff. But technically speaking, it would be anything that is a product of your efforts that you acquire after separation would then again be your separate property. So sometimes this becomes complicated. Sometimes people will come to a marriage and they have a retirement account, say, before marriage, then they contribute to it during marriage, and then let's say their marriage isn't that long, or maybe it is, but now they're contributing to it after their date of separation. Then it becomes quite a mix. But we have qualified domestic relations orders that we do that make that really can make that a lot simpler to deal with. So it can be complicated, and sometimes what people do is, to avoid all that complication, they want a prenuptial agreement or a postnuptial agreement just to clarify things so that everybody feels more at ease. And in California, frankly, prenuptial agreements are the courts like them because it makes things simpler. If people do divorce, they have a plan that they've come up with, and is more specific than, perhaps the vagueness of the law. And when you're talking about these mixed assets, things can get quite complicated, as I mentioned.
Okay, well, in my country, I can't pretend that I am often asked to vary the nuptial agreement. I think often people feel we did that and we don't want to ever talk about it again. But if I was to vary it, it would be by a new contract, a new deed. Is that how it works for you, Katja? Are they variable in Switzerland?
Oh, yes. Yes, you can draw up a new nuptial agreement anytime. And actually, I recommend to look at the nuptial agreement, every 5 years and look at it. Does it still meet our, needs and our interests and our values, or has something changed? Do we have now children, and we have to think about that? So I really advise to have a look at the nuptial agreement every 5 years. And actually, there are some who change, who make changes and amendments, but it has to be, again, written agreement and notarized, but it's no problem to change it. And actually, when I heard Suzan telling about how personal property becomes, common property, when you invest something in a house, in a home, like Kath said, this is not the case in Switzerland. So if you have own property, if you inherited something and you invest this in the family home, okay, it's still your property and you can get it back. Plus, like if the value was going up, you will have even more of that. So it's the best thing to invest personal money into common family home. When people start thinking about separation, because other than in Scotland and in California, it's not the date of separation which sets the key date for the separation of assets, but it's actually the divorce itself. Okay, so when this drags out for years, okay, it makes sense to either have a nuptial agreement on separation, saying, okay, from now on, this is separation of assets, which is very simple. They don't even need a lawyer to do that. They can go to the notary, say, as of today, no more common property, or you do this by court to have this separate, because if you just, expect litigation, you should do that as, to avoid complications.
Thank you. Kath, do you vary or do you renew?
Yes, I mean, again, we vary by way of entering into another contract, a new contract. But one thing I would say here is that what often happens is that we have cohabitation agreements, which then become prenuptial agreements. So here, if you are not married, you can still make a financial claim against your partner. Since 2006, we can do that. And what you've got to show is economic advantage or disadvantage. So it's quite common now, particularly when young couples are buying flats together, say, for example, or alternatively, if it's an older couple with assets of their own and they're just moving in together, that they'll enter into a cohabitation agreement. And what we tend to get quite a lot of is, they go off and they then marry maybe 2 or 3 years down the line, and those cohabitation agreements then become prenuptial agreements. So I do quite a lot of that. And then during the course of the marriage, then yes, absolutely. Oftentimes I'm instructed to vary again. I'm seeing a sort of a big uptick in people who are getting sort of big jobs and big promotions. And it's actually their employers who are asking them to enter into post-nuptial contracts so that any business interest they have or shareholding is actually excluded from the matrimonial pot. One other thing we do a lot of here are what we would term separation agreements, so that here we don't need courts to rubber stamp agreements, so that most couples will just enter into a separation agreement, will negotiate their own, whatever bespoke version of an agreement they want. We often use collaborative practice to get to that point, and then they just sit there with a separation agreement. and many of them don't even go on to divorce. They just you know, quite often, A, it's an added expense, and B, it's not necessary to finalise the finances. So many couples will have a separation agreement in place, but no divorce, and many carry on and go and cohabit. And then what you then have sometimes are bizarre competing claims of wives and cohabitees all looking to make a claim against someone, and then obviously the children as well. So it's complicated, but yes, the short answer is yes, we can vary, and we vary a lot.
Okay. Quite different to England. And Suzan,
Yes.
do you vary, and do you vary a lot?
Yes, actually, I wouldn't say there are some people that I work with that do vary a lot. They buy and sell property, and they have different ideas about who should own which, what portion of different pieces of property, something like that. So I would vary a prenuptial agreement with an amendment. So, you know, saying something like this provision will be replaced by this provision. So the amendment is not an entire new agreement. It's a much smaller agreement. So as long as it's in writing and it's signed by each party, and while it's not required, I do have agreements notarized. I think that's really important. And one of the things that comes up, I find, I mentioned younger couples with older couples in California. A lot of times what people will do, and this is allowed, is when they're older, they want to have provisions in their agreement about their estate plans. So something like, you know, if we were to, or maybe they have children from a previous marriage and this is a second marriage or something like that. And so they want to have some provisions in their agreement, and they want to add that, like, I want to make sure, because people can change their estate plans. So they would want to put something in there that they want to make sure that their estate plans will provide for this. And if they don't, then that would be a charge against their estate should they pass. So sometimes people will, you know, during their marriage, maybe they want to have a post-nup and they want to have it say, you know, actually, I want to make sure that my children from a previous marriage receive this. So that's something that people will change, so that they become living agreements. And because they don't have to be a whole, you know, big agreement again, then that amendment can have can be something that they feel comfortable with. And other couples, they feel relieved. It's done. They know that that agreement is in their safe deposit box, and they don't want to think about it ever again.
Thank you. And I'm guessing, Francesca, that the Italians probably don't vary their nuptial agreements very much like the English. You're on mute.
Sorry for that. No, there isn't a lot of variation, even if you can. The situation is very similar to the one Katja was describing. I think we have the same sort of Roman Napoleonic origin that sort of deals with this matter that we share in common. But one difference regarding what Katja was saying is that you can vary during marriage, but the most common choice is the separation of assets. This is what statistically the majority of couples choose when they marry, especially in big cities, especially sort of culturally or economically sort of elevated couples make that choice. And normally what happens is that there's sometimes is this choice in marriage when a couple had instead hadn't made a choice at the beginning. So there is this change during marriage. That is what we see really as typical kind of changes. Another difference respect to what Katja was saying is that our default regime doesn't end with divorce. It ends at the first hearing of the separation. That was quite a recent innovation in order to avoid the problems Katja was outlining. And so that makes it a bit easier, because before, what happened, a typical modification was to do that during the separation or divorce proceeding, to make things at least clear, so what was happening, because our proceedings could also last many years, and we have to go in Italy through a legal separation before you can divorce. So it's two different proceedings that, in case of conflict, can be both long, and so that was a problem.
But to be clear from the Swiss side, okay, you don't need to have a separation in court.
Yeah.
But if you do, you can ask for a separation of assets during, at this time. So that's a bit of difference. So you can do that. But there's no litigation before divorce, which is not necessary. Then you can make like a nuptial agreement to take care of this problem.
Now, I explained at the beginning that nuptial agreements are not binding in England, and the longer the marriage, or the more circumstances have changed, the more assets have been mingled, or the more needs require it, a nuptial agreement will just be a factor. Are there any circumstances, Katja, that a nuptial agreement will not be binding in your jurisdiction?
Well, if it's in agreement with the Swiss civil code, it will be binding. If it's not, like if it contains maintenance agreements or anything about children, then this part will probably not be binding to a Swiss court, which makes me really thinking about how to advise my clients, who are often binational or coming from another country. And I would always advise that we have like a cooperation with the lawyer from the jurisdiction where they come from their country, especially if it's UK, because it's very tricky to have nuptial agreements, and if it's not confirming, if it's like a UK nuptial agreement, it will probably not be binding for the Swiss court, but still you can have an agreement during divorce and trying to adjust it so Swiss court will accept this at the divorce. So this is possible. You can still have an agreement, to do that, to respect what they really wanted to have when they drew up the nuptial agreement in the UK, for example. And
a nuptial agreement's binding in Scotland?
Who knows? Is the honest answer. The only decided case that we've actually had goes back to 1982, and our Family Law Act came into force in 1985. So there's been no case yet decided post our 85 Act. But basically, the 82 case said that as long as parties were both adults, they'd made full disclosure, there was sufficient notice, yada yada yada, it would be binding. But there is provision in our 1985 Act, which says that agreements can be overturned. The exact terminology says agreements between parties to a marriage. There was a big case in court about 5-6 years ago where the actual definition of parties to a marriage was considered, and the sheriff principal in that case came down to say that, in fact, even parties who are not yet married but are negotiating a nuptial contract should be considered parties to a marriage. So we now know that, yes, potentially an anti-nuptial contract could be overturned by the court. So strong advice to clients is probably better to have it than not, but it may just be the basis of, it may just be an aide-memoire. It may just be, here's your schedule, this is what you had pre-marriage, this is what you think you're going to inherit, we've got that documented, and then it might work, it might not, but at least there's something there, to form the basis of a settlement going forward. So who knows is the answer.
And Suzan, you're sort of nodding agreeably. And it seems as if California and Scotland have more in common than I would have guessed.
Who knew?
Yes. Certainly not weather, but other things. Does that have a resonance with you, Susan? The sort of circumstances in which, you know, a nuptial agreement might not be binding.
Yeah, so technically, as long as the agreement complies with the requisite formalities, it would be binding. However, that I would also advise clients that this is something that, you know, you can't, it's not rock solid. And the more that the agreement is, you know, offensive in that, you know, it is so black and white that someone gets nothing, someone gets everything. The more it's like that, I believe the more the court would say, you know what, they're going to want to find a way to take some piece out of it. Now, I always include in my agreements a severability clause. And so that severability clause in the agreement would say if there's some provision in the prenup or the postnup that is not enforceable, that provision would be taken out, and that the other parts of the agreement would be they would be binding. So I think it's important that, you know, that agreements have something for the other spouse is perhaps, you know, not going to be getting, you know, as much property or any property. And the more that there's some balance there, the more they're likely to be enforced, in my opinion.
I agree with everything you've said, especially about the severability clause. How does it work in Italy, Francesca?
Well, as long as the agreement was regarding, you know, assets and made with the formalities required by the law, that is of course binding during the divorce. Any other agreement would not be binding at the moment, but as Susan was saying, even from a different perspective, nothing is written in solid rock. Things are changing. And I think we are moving towards a system that will more and more recognize some kind of validity to nuptial agreements. As I said, there is a law project waiting in Parliament that, of course, has been there since the pandemic and all the rest. And I don't know when and if it will be actually discussed, but that shows that there is a change, you know, in the way marriage has been seen, and the agreements between spouses or parties that will get married are going to be valued. This also comes, I think, from the EU legislation. One thing that couples can now choose is the law that will discipline their separation. And that is something that parties, especially in big cities, are binational parties or cross-border, are starting to consider. And so there is more and more an interest in finding places where you can actually start thinking of how you can deal with a future separation, what happens with choices that were made by the couple, like if one stays at home and is a full-time parent, how that will be valued. So this is really a topic that is changing, and so it's difficult to give certain, you know, definitive answers, and even the most traditional ones are not definitive anymore, I would say.
Mm-hmm. Thank you. And Katja, could I ask you, does your jurisdiction respect nuptial agreements from other countries?
Yeah, I think they try to, but it's not if it's really against Swiss civil code. Okay, that would be part that they would not accept. Like if there was some maintenance discussion in there, some maintenance agreement that is not according to Swiss law, they would not hold up in court. So it is really strongly advisable to get legal advice on this. If they're, if I have couples in mediation who are from UK, they had an nuptial agreement and they want to get divorced, and they have to get divorced in Switzerland because they live here. So they really have to be careful on what court would accept in this situation as Swiss court. And on the other way around, it's if they go back to the UK and something's missing in this court decree, in this divorce decree, you know, one of the spouses can go back to UK court, and UK court will not respect the Swiss court decree. So this is something that really needs attention, that you really need to check into and be sure that you know have in the end the result that you wanted to. So I have had different cases cross-border like that, and we have tried to, you know, put a balance in this. So we don't give something to Swiss court that they can just throw out, but to find a solution that gives spouses or future ex-spouses the best possibility to get what they really planned to do.
Yeah. And Cath, how does the Scottish system view foreign prenups or postnups?
I think again it would depend. I think it would depend on, you know, what the agreement said, and again the circumstances into which it was entered into. One thing that I do a lot with clients who may have a choice of jurisdictions, you know, just for example, recently I dealt with one where my client was South African and her intended was Scottish, but they thought they may live in South Africa at some point. They thought they might live in France at some point. And my advice to them was basically get mirror agreements. You know, go to a lawyer in France, go to a lawyer in South Africa, take my version and get them to create mirror versions of that. Because as far as I'm concerned, that's really the only surefire way of making sure that in any respective jurisdiction in which they might reside, that those agreements might be upheld. But obviously the caveat, I think, from this discussion is that it's not set in rock anywhere. So, you know, but it's the best we can do.
Susan?
I concur with Cath. So what I would advise clients is that in an effort to bolster the likelihood that their premarital agreement will be enforced beyond its place of execution, that the couple includes a choice of law clause specifying the law to govern the validity and enforceability of their premarital agreement. So most American courts will enforce choice of law clauses as long as the couples choose the law of a jurisdiction with which they have a substantial relationship, and that the law is not contrary to a fundamental public policy of the foreign state. So for example, in California, we're a no-fault system. So if there is something in the agreement that is based upon fault, so it really, if there's something that really just flies in the face of the foreign state, the foreign state would be California in my situation, then there would be a problem. But I've worked with cross-border cases, and what I really like is, as Cath mentioned, when you work together with a lawyer and if that's what the couple is thinking, we might live here, we might live there, having the agreement, looking at the agreement from the perspective, communicating and working collaboratively with an attorney in another jurisdiction. And that's when I have found that agreements really are feel like they're most enforceable.
Yeah. And Francesca? You're on mute.
Yeah, I was looking for the button. So it really depends. If we're applying Italian law and to a marriage, an Italian court would not recognize a nuptial agreement that has provisions regarding maintenance or child support, or it would be really difficult to have that seen. It could, there is some case law of agreements that have been considered binding of the intention of the parties, that were not really changing anything in the marital system. It was more of an agreement between two parties. An example was of a husband who had invested money in in the house of the wife, And the agreement was that he would only ask for the money in return in case of divorce. I think if that had been an agreement dealt by, reached by Italian citizen, it would probably not have been recognized. Instead, it was easier for the court to see this as an agreement that made some sense, and it was not really involving principles that are not negotiable for Italian law, and it wasn't seen, I think, as a real nuptial agreement in some way. So as I said, you can have our courts apply different laws according to the EU regulation, but I haven't seen, and I don't think there is any real case law that has recognized nuptial agreements, even in these cases. I think it's very difficult, especially when it considers maintenance or child support.
So we're all familiar with the choice of law clauses, and I think we're all familiar with the concept of mirror agreements in other countries. But it seems to emphasize the importance always of taking cross-border legal advice if you're dealing with international clients who are likely to reside in other jurisdictions, or clients who are likely to buy assets in other jurisdictions. So are there any other comments you'd like to make before we close?
Thank you.
Right. Thank you everyone for joining us. Thank you for listening to us, and have a good evening, morning or afternoon, wherever you are.